Good morning. Today I'm joined by Secretary Anthony Foxx of the United States Department of Transportation and the United States Attorney for the Southern District of New York, Preet Bharara. We are here to announce a new development in our ongoing effort to protect the American people and to hold accountable those whose actions harm and endanger consumers nationwide. The Department of Justice has officially concluded its criminal investigation into Toyota Motor Company regarding the widespread incidents of unintended vehicle acceleration that caused panic for Toyota owners between 2009 and 2010. Those incidents produced one of the largest consumer recalls in the history of the automotive industry. Today, we can say for certain that Toyota intentionally concealed information and misled the public about the safety issues behind these recalls. Now, our years-long investigation, criminal investigation, examined the way the automaker disclosed complaints about problems of sudden acceleration associated with many of its most popular Toyota and Lexus models. Rather than promptly disclosing and correcting safety issues about which they were aware, Toyota made misleading public statements to consumers and gave inaccurate facts to members of Congress. And they concealed from federal regulators the extent of problems that some consumers with sticking gas pedals and unsecured or incompatible floor mats that could cause these unintended acceleration episodes. Now, while Toyota conducted a limited recall of some vehicles with floor mat issues in September of 2009, the company delayed a broader recall until early 2010, despite internal tests warning of the dangers posed by other unrecalled vehicle models. As Toyota admits in the statement of facts that has been filed along with the criminal information in this case, the company made, and I quote, "made these misleading statements and undertook these actions of concealment as parts of efforts to defend its brand," unquote. In other words, Toyota confronted a public safety emergency as if it were simply a public relations problem. And they mounted this cover-up despite widely documented incidents and even tragic accidents like the one that took the lives of an off-duty California Highway Patrol officer and members of his family. As part of the resolution of this case, Toyota will fully admit wrongdoing. It will pay a financial penalty of $1.2 billion. And going forward, the company will submit to rigorous review by an independent monitor that will examine and assess the manner in which Toyota regularly reports safety issues to the public and its regulator. The $1.2 billion payment represents the largest criminal penalty imposed on a car company in the history of the United States. This is appropriate, given the extent of the deception carried out by Toyota in this case. Put simply, Toyota's conduct was shameful. It showed a blatant disregard for systems and laws designed to look after the safety of consumers. By the company's own admissions, it protected its brand ahead of its own customers. This constitutes a clear and reprehensible abuse of the public trust. That's why this agreement is really so important. It secures concessions that will change the practices of the company, and I believe of the industry, to better ensure public safety and awareness. It punishes illegal and fraudulent conduct in the strongest possible way, and by including a strong independent monitor that will allow us to reform the company's behavior and confirm that Toyota's talk of fundamental changes is backed up by fundamental action. This agreement will enable us to accomplish a great deal more than we otherwise would have. And my hope and expectation is that this resolution will serve as a model for how to approach future cases involving similarly situated companies. When car owners get behind the wheel, they have the right to expect that their vehicle is safe. If part of the automobile turns out to have safety issues, the car company has a duty up front to tell customers about them, to fix them quickly, and to immediately tell the truth about the problem as well as the scope of that problem. Toyota violated this basic compact. Other car companies should not repeat Toyota's mistake. A recall may damage a company's reputation, but deceiving your customers makes that damage far more lasting. Under the terms of the criminal information filed today, Toyota will also be charged with wire fraud. The department will defer prosecution of Toyota for 3 years, provided that Toyota complies with the agreement in every respect and continues to fully cooperate with federal authorities. But let me be clear, the department has not and will not consent to foreclose criminal prosecution if the terms of this agreement are not rigorously adhered to. Today's announcement underscores the fact that the Departments of Justice and Transportation remain firmly committed to protecting consumers, ensuring the safety of the American people, and combating fraud in all of its forms. No company is above the law, and we will never tolerate activities like the conduct at issue in this case. That's why my colleagues and I will continue to meticulously and deliberately investigate any such matter that is brought to our attention within this industry or beyond, using every tool, using every resource, and using every authority at our disposal to ensure that justice is ultimately done. Now, I'd like to thank everyone who made this agreement possible, particularly United States Attorney Preet Bharara and the outstanding lawyers in the Southern District of New York, some of whom are with us here today, who led this investigation and did really groundbreaking work. Their work was simply outstanding. I'm grateful also for the committed efforts of officials, agents, and staff at the FBI, as well as dedicated public servants at the Department of Transportation, as well as at NHTSA. I'd like to turn things over now to my friend and colleague, Secretary Foxx, who will provide additional details on today's agreement. Secretary Foxx.
Good morning. I want to first thank Attorney General Holder and the entire Department of Justice for their leadership on this investigation and for bringing it to a close today. I also want to thank U.S. Attorney for the Southern District of New York, Preet Bharara, and his entire team for their outstanding work. Almost 50 years ago, when Lyndon Johnson signed the legislation that created the Department of Transportation, he said that our top priority was to protect the American people as they move about the country. That is our first task. When the traveling public is put at risk of injury or worse, it's up to us to follow the evidence, to find the problem if there is one, to ensure that it gets fixed, and to take steps necessary so that it never happens again. It's a responsibility that we treat as a matter of life and death, because it is. That is why 3 years ago, we pushed Toyota to recall vehicles for problems with unintended acceleration. Our department never wavered in our commitment to uncovering the truth, to ensuring that Toyota lived up to the level of safety we expect of them. So we harnessed the best technology and data available to us. We stalked the evidence. We identified the problem despite what we know were overwhelming obstacles. Obstacles that in some cases were put in our way on purpose, not to help our investigation, but to hinder it. At DOT, we did not stop there. We also held Toyota responsible for failing to act quickly on this and other recalls at the time, levying record fines of more than $66 million. Today, the DOJ is taking another crucial step to hold Toyota accountable. There were many offices that were involved in helping DOT in this effort, including the Office of the Secretary. But there are two agencies we wouldn't be here without. Those agencies are the Office of our Inspector General and the National Highway Traffic Safety Administration. I am proud of them and of their persistence and their competence and their skill. And all of us who traverse America's roads should be grateful to them as well. The agreement DOJ reached today is further proof that on our roads and with our laws, we hold those accountable who need to be held accountable. And I hope, and we all hope, that it sends a powerful message to manufacturers to put safety first, that if they conceal information or mislead NHTSA on issues involving safety defects, they face serious consequences. If this story has a legacy, let it be that. Thank you all.
Good morning, everyone. Thank you, Attorney General Holder and Secretary Foxx. Today, one of the largest car makers in the world stands charged with a criminal offense. Toyota Motor Corporation is in that position because it cared more about savings than safety, because it cared more about its own brand and bottom line than the truth. In its zeal to stanch bad publicity in 2009 and 2010, Toyota misled regulators, misled customers, and even misstated the facts to Congress. Even while giving unequivocal assurances that it had fully addressed a grave safety problem, Toyota knew full well that the problem of unwanted acceleration persisted. As the Attorney General has said, because of its campaign of disinformation, Toyota is facing federal wire fraud charges, is admitting that it misled the public about safety problems in its vehicles, and is paying a $1.2 billion financial penalty, the largest payment of its kind in the auto industry. That unprecedented penalty is significant, especially in light of the relatively paltry penalties Congress has authorized the Department of Transportation to pursue. And while the criminal charges are being delayed for now, Toyota will be effectively on probation for 3 years, subject to special reporting requirements to the government, and answerable to an independent monitor, as the Attorney General described. To elaborate a little bit on the facts, and further to the Attorney General's remarks, the backdrop of this case is Toyota's long history of problems with unintended acceleration in its cars. As far back as 2007, Toyota knew about the susceptibility of accelerator pedals in its cars to get stuck under floor mats. But despite internal reports that identified problematic designs, Toyota resisted all vehicle recalls in 2007, negotiating with the National Highway Traffic Safety Administration a very limited recall of just certain all-weather floor mats. No vehicles, just floor mats. At the time, Toyota was positively jubilant about that result, noting in an internal email that it had saved, quote, $100 million plus in unnecessary costs, close quote. Well, 2 years later, tragedy struck. On August 28, 2009, a family of 4 was driving a Lexus sedan on a San Diego highway. The accelerator pedal in their car became stuck under an unsecured floor mat. The car reached an acceleration of over 100 miles per hour and could not be stopped. Ultimately, the car crashed and all 4 members of the family were killed. As you may recall, the immediate aftermath of that fatal accident brought intense public scrutiny as well as multiple investigations. And in that moment, in a misguided and ill-advised effort at crisis management, Toyota made the fateful decision to mislead the public to protect its brand. Rather than come clean, the company covered up and misled again and again and again. In the wake of the accident, people wanted assurances, and Toyota gave them. The problem is, many of those assurances were false. Repeatedly and publicly, Toyota assured the world that it had taken care of the problem of unintended acceleration. For example, in November 2009, Toyota stated that it was, quote, very, very confident that it had addressed this issue, close quote, of unwanted acceleration. That was false. In December 2009, Toyota similarly stated that it was, quote, highly confident that we have addressed the root cause of unwanted acceleration, close quote. That was false too. Later, in December of 2009, the company said that it had, quote, absolutely not minimized public awareness of any defect or issue with respect to its vehicles, close quote. That was also false. All of these finely crafted public reassurances were false for at least 2 reasons, as the documents filed today make clear. First, under pressure from transportation authorities, in September 2009, Toyota recalled 8 models that its regulator itself had identified as having floor mat entrapment problems, floor mats getting stuck. But Toyota knew from its own engineering reports that at least 3 additional models, including the best-selling Corolla, were just as susceptible to floor mat entrapment as the cars they had recalled. And therefore, there were many, many defective cars remaining on the road. So the truth is that Toyota hadn't fully addressed the problem after all, despite all the public pronouncements. Second, at the very same time that Toyota was blithely giving all those assurances about addressing the root cause of the problem, the company had hidden from the public and from authorities a second cause of unintended acceleration. That was a problem with sticky accelerator pedals caused by the use of a certain plastic material inside the pedals that sometimes resulted in the pedal being stuck in a partially depressed position. That, as Toyota later admitted, was a grave safety concern, but Toyota chose not to mention it. As Toyota now admits, the company failed to disclose the sticky pedal problem to U.S. regulators, even though It thought the problem was serious enough that it had ordered a design change for new cars in Europe and had scheduled a fix for the United States cars as an urgent measure. Urgent is their word. But in October of 2009, in the midst of the firestorm over the San Diego accident and unwanted acceleration problems, what did Toyota do? It quietly canceled the sticky pedal fix in America. Just canceled it. What's more, in connection with this abrupt and inexplicable cancellation and in direct violation of its own standard policies, Toyota executives directed employees not to put anything about the cancellation in writing and to avoid a paper trail. All of this was done, as Toyota also admits, to prevent its regulator from finding out about it. In many ways, this was a tale of two companies. To the unsuspecting public, Toyota said one thing, but internally and in secret, Toyota said something different altogether. As bluntly put by an employee who became concerned about what Toyota was saying in January of 2010, quote, "Idiots. Someone will go to jail if lies are repeatedly told. I can't support this." Close quote. Every day, tens of millions of Americans take to the roads in their cars. They have an absolute right to expect that the companies manufacturing those cars are not lying about serious safety issues, are not slow-walking safety fixes, and are not playing games with their lives. That's why we have undertaken this landmark enforcement action, because companies that make inherently dangerous products must be maximally transparent, not two-faced, and the entire auto industry should take notice. I want to thank the many people who allowed us to get to this point today. First, I want to thank the Attorney General and the Deputy Attorney General and the Department of Justice for their unwavering support of this long and laborious investigation. I also want to thank the FBI and especially George Venizelos, the Assistant Director in charge of the New York Field Office, and his team, including FBI Special Agents Brian O'Hara and Samantha Lockery. I also want to thank the Department of Transportation, represented here by Secretary Foxx, its Office of the Inspector General, represented by Inspector General Calvin Scovel and their team, including Special Agents Brian Smith and Dennis Ocampo. And finally, I want to acknowledge the career prosecutors in my own office. They are Bonnie Jonas and Sarah McCallum, the Assistant U.S. Attorneys handling the prosecution, their chiefs Anjan Sani and Mark Berger, our money laundering and asset forfeiture chief Sharon Levin, as well as the Chief Counsel June Kim and Deputy U.S. Attorney Richard Zabel. They all have worked very, very hard in a complex case over a long period of time, and people should be grateful that there are public servants like them who work on